Let's roll.
Hello and welcome to the Must Read Alaska Show. Here you get relevant and timely content you won't find anywhere else. You can learn more by going to mustreadalaska.com, and this show can be found on YouTube, Facebook, X, and your favorite podcast site. Let's talk truth about politics, the economy, and all things Alaska. Now, the host of the show, former state legislator, combat veteran, small business owner, and all-around great guy, Ben Carpenter.
Hello, folks. Welcome to the Must Read Alaska Show. I'm Ben Carpenter, your host and guide on a journey of discovery of truth and independent-minded thinking. Must Read Alaska exists because discovering the truth is hard. It calls upon us to be relentless in defense of common sense, our faith in God, and the exceptional values enshrined in our Constitution. Freedom is not free. It is not for the timid. It was not secured by the weak of heart or mind. Maintaining freedom requires every one of us to be alert to daily encroachments in our liberties and on the grand deceptions of those seeking power and control over others. Every generation must pledge their lives, their fortunes, and their sacred honor, and we must never take our freedom for granted. We are not anti-government. We are pro-government, of the people, by the people, and for the people. And today we have a very special guest with us. Attorney General for the state of Alaska, Treg Taylor, has graciously agreed to spend some time with us discussing the grand jury, the Alaska grand jury. Hello, Mr. Taylor. Welcome to the show.
Well, great to be here, Ben. Thank you. I love the introduction.
Thank you very much. This grand jury issue has been brewing for a number of years, and I feel like there's some momentum here to finally find some resolution. And I'm glad that we have an opportunity here in the next 45 minutes or so to have a conversation, to set the stage for folks who may not be paying attention and may not fully understand what I'm talking about right now. The Alaska Supreme Court has, through their own administrative procedures, identified the Attorney General as the person responsible for determining when a member of the public may present information to a grand jury. Up until this most recent administrative order, it was kind of nebulous as to when a member of the public could access or gain access to the grand jury. Do you believe that it is constitutional for the Attorney General to be the kind of the gatekeeper of the grand jury?
Oh, that's a great question and a hard question right out of the gate. I think there are some definite constitutional issues with that. One, can the Alaska Supreme Court assign a duty like that to the Attorney General's office? That's a separation of powers issue. And then also there's the whole idea, is it a good idea to do in the first place, right? A lot of the complaints that we see from the public about public corruption, given the nature of what I do as the Attorney General, where I really think I'm a unique Attorney General, and that I have really three jobs, so that no other state has this. So one, I'm the lead prosecutor for the majority of the prosecution that takes place in the state. Obviously, the feds prosecute in the municipality of Anchorage, and Juneau also do misdemeanor prosecutions. But for the vast majority, 98% of the cases in Alaska, we prosecute from this office. The other part is I advise all of the executive branches, offices, commissions, departments, and all those attorneys are in-house here at the Department of Law. A lot of other states, those attorneys they don't report to the Attorney General. They actually report to the commissioner of those various departments or agencies. And then the third one, which is absolutely unique, is that I am the general counsel for the governor's office. And so three jobs keep you very busy, but it also puts you in the public spotlight quite a bit because you're constantly making difficult decisions. You're constantly having to exercise discretion, whether it's how do we use the limited budget that we have within the Department of Law, whether it's to pursue a prosecution or not, or how to pursue that prosecution. And anytime you're dealing in that realm, tensions run high, right? You've got survivors of horrific events. You've got people that homes have been burglarized, so it's a very personal thing, right? They feel like they don't their home, which is supposed to be a respite and a safety area, now feels like there's danger lurking. And so completely understandable that the passion runs high. But because of all that, it's a long way of saying a lot of these charges of sort of public corruption are sort of aimed at my office or people within my office. And so having me be assigned the gatekeeper, and so we know what we're talking about. Like, the gatekeeper is responsible for making sure this is an appropriate issue under the rules that the Supreme Court has laid out. Gatekeepers make sure that these issues that are coming forward, as the public complains about certain aspects of government, or they put matters before us, the gatekeeper is designed to make sure that it meets the requirements of what an investigative grand jury is supposed to look like, that it's a matter of public welfare and public safety, and then the matter affects a broad group of people, not just a single individual. And those are the rules that set out by the Supreme Court in that rule. And so, yeah, it is because of the inherent conflict. Anytime anyone in my office is implicated, it puts us in a very difficult position. And so our response to that is, anytime there's an allegation of that comes before us that involves a member of the Department of Law, we immediately go to independent counsel. So that's outside independent prosecutor, someone that does not work for my office, someone that does not affiliated with my office. But even that, as we heard last night at the hearing, has some issues involving that are just make it very difficult to administer this part that the Supreme Court wants me to administer.
And for the public's knowledge, if you're listening to this, the meeting that the Attorney General referenced was a meeting down in Kenai at the Kenai Peninsula Borough building. Kenai Peninsula Borough Mayor Michicki and the Attorney General met with the public and discussed grand juries at that meeting. So this opportunity for us to have a conversation was totally separate and not related to that meeting, but it was a good primer for this for a follow-on conversation here. You've established new procedures for the Department of Law employees to follow when a member of the public desires to meet with a grand jury. Can you give us kind of an overview? I know we showed a bunch of slides from the website at this other meeting, but can you just kind of give us a verbal overview of what the process looks like?
Yeah, and before I do that, I'd just like to harken back. So there used to be the first Supreme Court adopted a grand jury handbook, and in that handbook, it kind of goes through the different ways that a person can bring a complaint to an individual grand jury, and in that they one of the points was, a citizen is at liberty to apply to a grand jury for permission to appear before it in order to suggest or urge that a certain situation should be investigated by it. So it's basically talking about how an individual who thinks that they've seen public corruption, or they've watched a trend and they think there must be something there, there's this way this describes this application process to an investigative grand jury. And the investigative grand jury holds all of the power and authority in this situation, right? They can subpoena records, they can have witnesses appear before them, they can conduct an investigation, and then so they have all the cards. So how does an individual access that? Well, I believe this is the first time in the history of Alaska that we have a written procedure of how an individual applies to have an investigative grand jury perform its duties. And so basically the process is this. We've got it all on our website, the Department of Law. If you go there, you'll find a tab called Investigative Grand Juries, and there's a fax there that gives you sort of some of the most asked questions that we have. But basically it's a form that you fill out, and you kind of, what is the public safety or public welfare issue that you would like an investigative grand jury to investigate? And then there's a place where you can drag documents in there to submit with your submittal. And then there's a series of questions, and the questions are really asked so that the individual sees, oh, maybe this isn't a matter that's supposed to be before an investigator. Maybe this dispute that I have with my neighbor really isn't a matter that is right for an investigative grand jury. There's other avenues that I should be pursuing. So we kind of walk the submitter through those. And so at each one, they say, yes, to the best of my knowledge, this is a matter of public welfare and public safety. And then you go through, to the best of my knowledge, you sort of signify that. We walk you through those steps under the rules that the Supreme Court has put forward. And then at the end of the day, you sign it and submit it, and then it comes to my office. So it's actually a pretty easy procedure to follow.
Okay, thank you for that. And as far as I know from the meeting and looking at the website, that's a pretty good summary for those who are listening or watching this. You can go to the Department of Law's website and look at this process for yourself if you would like. So it's all matter of public record here. You've already spoken about this, the constitutional separation of powers here just a few minutes ago between the executive branch and the judicial branch. As the Attorney General, are you required to follow the administrative procedures that have been established by the court?
The court rules are the court rules, and I'm bound as a member of the bar to adhere to those rules. Now, obviously, in adhering to those rules, like any prosecutor or any type of litigation that we're thinking of, whether it's civil or criminal, there's a lot of discretion that is housed within this department, and I can use that discretion in a way that is adherent to those rules, but also allows more cases to be heard by investigative grand juries. Because I think right now we're in a period of sort of a deep distrust. It's maybe not all Alaskans, but there are certain groups of individuals that feel disenfranchised, that feel like their complaints have fallen on dead ears for a long, long time. And so, this whole process and the rule changes are actually instigated by me, because I was hearing these complaints from individual Alaskans. And so I went to the Alaska Supreme Court and I said, Chief Justice, you really need to solve this issue. No one knows what the rules are, right? The individual Alaskans have this right to apply to a grand jury to investigate public corruption. And yet there are no rules. And the rules are tough too, because most of those rules, and in the Constitution itself, if you read the provision, most of that is actually talking about a criminal indictment, right? And then it's confusing to when it switches from a criminal indictment to this investigative mode that a grand jury also has. And so we were in desperate need of guidance from the courts on how that should look. And at the end of the day, they came out with these rule changes. Now, I didn't agree with all of the things that they did. In fact, they didn't accept some of our input, including the fact that I'm the quote gatekeeper for these investigative grand juries, which again, I don't think I have any business being the gatekeeper. So that's one of the thoughts where I kind of disagree with what the Alaska Supreme Court did in those rules.
Well, what would be stopping you from establishing your own policies that you think better suit the access to the grand jury and don't violate constitutional rights of people or put you in a position, I guess is the better way to say it, put you in a position of being the gatekeeper of determining whether somebody, or, you're going to ask questions. There'll be somebody that reviews the questions. There'll be a decision. If somebody doesn't agree with the decision, then there's controversy. Why wouldn't it be in Alaska's best interest to just be a scheduler for the grand jury and allow the grand jury to take 5 minutes and review a matter that's brought before them and decide whether they want to pursue it or not, and it gets scheduled on a calendar, and that be the role of the Department of Law, is just in helping facilitate the actual meeting, not in deciding whether there's a matter that needs to go forward or not. I mean, it's ultimately the grand jury's decision. So why qualify it beforehand? Wouldn't it be better for Alaskans if that policy was in place?
No, there's a certain line of thinking that I have a lot of empathy for that line of thinking. I really do. But then there's also this other side of things, right? So I like what you first said about the putting together a procedure, right? And that's exactly what we did. It's clear as day what people need to do. And that's why we put it out there in writing. One of the reasons I wanted it in writing was so that somebody could challenge it, right? If they think that we're way off base, then they can challenge those regulations. Or if they think that we need to do something different, they can bring that those ideas forward, or they can sue the state in a court of law to get those rules, those procedures changed. But I wanted people to have the opportunity to do that at a base. But then there is the other side of this in that have you ever served on a grand jury or in a jury?
Jury, yes. Grand jury,
Yeah.
no. I was an alternate at one time for a
So
jury.
we've got Alaskan families, right? And these individuals that are called to serve. It's a public service, and it doesn't cost, and it doesn't come without cost, right? These individuals, they don't get, what is it, $12 a day that a grand juror gets paid, and yet they're taking time off work, they're taking time away from their family. The one public, the one grand jury that we know of that became public because of some other case that came out of it, that lasted 8 months. That grand jury was impaneled for 8 months investigating that issue, and you can only imagine what the cost was to that individual as far as work time and time away from his family or her family. And so there is this balance that there has to be some rules or regulations that sort of funnel people in and make sure that these complaints are not just being used to attack an individual, or they're not being sort of weaponized like we sometimes see in the various litigation that goes on, whether it be civilly between two neighbors or not. But we want to prevent this from being weaponized to badger individuals, and so we want to make sure that it does fall within the rules of the Supreme Court, and then move it on to a grand jury. But as I was indicating, I am the gatekeeper. Whether I like it or not, I'm the gatekeeper. And I intend to be a very poor gatekeeper. That's the policy. That's where I have discretion, right? I can be a very poor gatekeeper. And I think that's necessary right now because of the distrust that we're finding within certain segments of Alaskans. And they they don't trust the justice system. They don't trust our elections. They have all kinds of doubts about the things that they've seen and heard. And so we need to be more open right now and have more access to grand juries than I think it was necessary 20 years ago. So that's what I intend. I intend to let a lot of these things go through, so that these people's concerns can be heard in a grand jury. And again, like I said, the grand jury has all the power. They can do various things. And the interesting part about it is once it enters a grand jury, then it becomes a very confidential process. And the public doesn't even necessarily know what the grand jury is with it. They won't know, right? Unless it results in a report that's made public at the end of it, they might not even know under the old system whether a grand jury even met. So someone might have had concerns that went to a grand jury. The grand jury decided not to act on those concerns, but that individual would never know that.
And that secrecy is part of the constitutional requirements of the grand jury.
Right. The confidentiality of a grand jury, right? Because you can see why it would need to be confidential and when we're indicting on criminal charges, because there's a massive amount of just the fact that you're being indicted could destroy your own business, right? Or could destroy your reputation. So that's why those are confidential. And we want to keep it confidential for the jurors so that they can do the right thing without fear of consequence afterwards, right? We don't want, to identify the grand jurors publicly so that now if they indicted someone of power, that individual can then go after them. And so that's one of the beautiful things about one of the good things that did come out of this, and that those written procedures that we have is, aside from it being a known process, anybody can follow it, is that it also, that side of it is now not confidential, right? Portions of that. Obviously, we're going to protect the name of the people that submitted these things because, again, they're coming from a position and probably implicating someone that has some type of authority or power within state government, right? And so we want to make sure we protect that. But what we can do, and I intend to do on our website as these come in, and we've already actually received one through the website, and it's gone out to an independent prosecutor outside of my office to impanel a grand jury on. And the reason why it immediately went out to an independent prosecutor is because it implicated a lot of people within my department, right? And so that was an automatic out to an independent prosecutor, and that independent prosecutor will conduct and be the attorney. Basically, that independent prosecutor is the attorney for that grand jury. So when the grand jury wants to subpoena a witness, they have a lawyer there that's able to do that and talk them through the processes of law that are necessary to get all the information they need to consider on the matter. So on the website now, for the first time, is going to be public. Hey, this is what this grand jury request was all about. This is the allegations that are in that grand jury. Now, it might be public official in the, and I hate to call out a department, so I'm just going to make up a department. Department of Reptilian Studies has been abusing his position by being unfair to iguana owners, right? So that's the issue. We'll have that publicly on the website. And now what we can do, because it's outside the grand jury process, is when I give it to when I give it to a prosecutor, or I give it to an independent prosecutor, I can indicate this matter has now been given to a grand jury for review, right? And before, no one ever knew that, right? That was all confidential. And then once it goes into the grand jury, now that confidential process occurs. But at the end, if it results in a report that becomes public, because I think those reports should become public, then we can also say it resulted in this report and have that PDF of that report right there for anybody to see. What that'll allow Alaskans to do is, they say, well, I think that there's public corruption within this police department. And they can go through and they can go, oh, look, somebody else thought the same thing, and that one did result in a public report. So let's look at that, right? And so I think it behooves us to keep sort of a semblance of a track of those, so that individuals can know what's been investigated, what hasn't been investigated. And it'll also keep, I think, the number of investigative grand juries that are needed, because people will see, okay, this has already been looked at.
It strikes me as there's going to be a number of people, and probably their faces and their names, but if we really stop and think about this, there may be people who are like, you know what, I think I need to come up on the radar here with this issue. I don't trust the administration, the government, to give me a fair shake. And now I have to go through this process where I tell the government my case and trust that they're going to allow that information to come before a grand jury. Why wouldn't they be looking at that and saying, you know what, this is outside my constitutional responsibility or my rights to be able to keep things secret before they get into a grand jury? Like, it's no longer secret if the Department of Law is being the gatekeeper, as we've said, but making its own discretion as to whether this needs to move forward or not. I mean, what do you say about the people who say it's supposed to be secret and you're making it not secret?
Right. I'm always going to sort of err on transparency side. And I think the transparency of us sort of giving an overview, again, I don't want the job as gatekeeper. If this went to a special commission that under statute is formed, I would happily cede this to that commission to decide. And those are things that we're talking about, because, right, this was just the first response to those rules, what you find on our website. And we've had multiple meetings since then within the Department of Law, how we can make those better, how we can increase public confidence in the process, how we can remove our footprints or our fingerprints even further from the process. And we've thought about setting up a commission. We've thought about doing a lot of different things.
Have you thought about just allowing the grand jury to decide whether they're going to investigate or not?
Yeah, and that has sort of been my policy. Like I said, I'm going to let these things go through, and I think that people are going to find that. There was, for example, we know, I guess I don't know if I name names here, but there's a gentleman that has a concern, right? Last night at that meeting, and I invited him. I said, hey, I'll tell you right now, you submit this in this process, and I promise you, I will push that out to an independent prosecutor. In fact, I've already got one ready to go that has had no employment history with the Department of Law, which is very rare, because when you do all the prosecution in the state, you have ties to all these prosecutors that are retired or have left to go into private practice. But we did manage to find an individual willing to take some of these projects off that did not come through our department. And so I'm really excited about that. But I would love to pass off that to her or him to bring before a grand jury and have them decide what the issue is. But that's sort of where we are at. I think if you allowed anybody to sort of come in and take a grand jury and ask them to investigate, I still think there has to be some type of process, because otherwise it would be pretty chaotic, and it would also make my other job, one of my primary responsibilities to prosecute individuals, very difficult, because when these grand juries are impaneled, we keep them busy because we're constantly doing criminal indictments, right? And so we recognize that if we did that type of process, it would greatly increase the man hours required from both my department and from people serving on grand juries, because we'd have to impanel a lot more grand juries.
What if that's what's necessary?
And again, I think that is definitely a policy call that someone can make. I think I think there's a part for the legislature to play. You yourself had legislation that sort of addressed some of these issues. We saw legislation prior to that. I think Mayor Machicki was talking about, when he was a senator, the legislation that he had introduced on this. So people have been slowly working on this problem, and I think there just hasn't been enough interest or enough desire within the legislature yet to sort of come up with a practical solution that takes sort of the government fingerprints off the process, so that people can have confidence in the process.
Speaking of confidence in the process, should the Department of Law allow a issue brought forward to go to the grand jury? Should the grand jury be allowed by the Department of Law to investigate a matter concerning public welfare and safety, and in their finding, in the execution of their duties, be able to request that prosecuting attorney who's attending their proceedings, like you just talked about, to initiate an indictment based on their investigation? Or is the only outcome that the Department of Law will support a report?
No. So in the first iteration, and this is another area where I disagreed, in the first iteration of the rules, they actually had two successive changes to the rules. Their first change to the rules made it so that an investigative grand jury could not indict. But then I think they realized that they had made an error. And so they changed the rules. And so now an investigative grand jury at the end of the process can issue a public report and can indict on a criminal charge. And so I think that is appropriate. That is well within the constitutional responsibilities of a grand jury. That's the whole reason we have them. And so that is a definite possibility on these. And so, that's a good thing.
So the Constitution specifically says that the right of the grand jury to issue a report, to investigate and issue a report, can't be suspended. Can the right of the grand jury to issue indictments be suspended?
I don't know. In my opinion, no. That is a key responsibility. And the provision that you just mentioned is the very last sentence under the Alaska Constitution. Everything above it talks about their duties on the indictment side, on the criminal side. And then we've also made a policy choice, and all states aren't like this, but we've made a policy choice in this state that all criminal prosecutions have to start with indictment. So every criminal prosecution we do has to start with a grand jury looking at the facts and saying, yes, we think there's something here, it should be prosecuted, and it comes out of that process. Other states aren't like that. We do have that. And so that is a right that has been conferred on the accused in the scenario.
It goes into the duties of the prosecuting attorney with regard to the statutes governing the grand jury, and people can look that up as matter of public record as well. 3 duties of the prosecuting attorney. One of them is in the case that law enforcement has arrested somebody on they actually got caught committing a felony, then that instance or that incident has to be brought before a grand jury in order for the indictment to continue. That's number 1 responsibility. Number 2 responsibility is if there's suspicion that somebody has committed a felony crime, that the prosecuting attorney brings that indictment before the grand jury, and then if they return a true bill, then it causes the arrest of that individual to be held accountable. And then there's that third responsibility listed there that says at the behest of the grand jury, the prosecuting attorney would draw up an indictment for whatever thing they did throughout their investigation. This is where the stumbling block has been in the 6 years that I served in the legislature, where we were trying to find some way forward. The courts counsel and the deputy attorney generals, your deputies, were vehemently opposed to any grand jury being allowed to investigate and indict. The words, well, we're going to have a runaway grand jury came forward. So the question that I've got is, this sounds great to me that Attorney General Treg Taylor, I am sorry, Treg
You're
Taylor.
fine. I've been called worse. So
yeah, it's recorded for posterity now.
Yeah.
That your opinion is that you're going to take a loose interpretation of the policies that you've put forward, maximize the amount of access that people have to the grand jury.
Yes.
But that hasn't always been the case. I mean, like decades, it has not been the case where people have access to the grand jury, or that grand juries are even allowed to investigate matters that they want to. So the question is, this process where the courts and the executive branch, namely Department of Law, have gotten together and said, hey, we're going to come up with this process by which we're going to qualify people's access to the grand jury. There's no perfect solution to the amount of QA/QC or double checking or making sure that everything's going right that the courts or the executive branch could do that doesn't have the potential to run afoul when you have somebody in there that's willing to abuse the system like we've had for decades.
Yep.
So why would it not be in the best interest of the state of Alaska for the Attorney General to push back on the courts and say, look, there is a constitutional requirement that people have access to a grand jury. We trust 12 to 18 members of a grand jury to decide when it is appropriate to take somebody's liberty away, meaning we're going to cause a indictment to go forward and they're going to get arrested and put in jail. We trust 12 to 18 members, a majority of which, to make that decision, but we aren't trusting them with a decision to decide what they want to investigate and what they don't.
Well, I'm going to have to disagree with you a little bit on what you just said. The right belongs to the grand juries. The constitutional right doesn't speak about individuals coming before grand juries. The Constitution speaks about the right of the grand jury to investigate and make recommendations concerning the public welfare and
I'm in agreement with you.
Right.
The grand jury gets
even that first grand jury handbook talks about, and I read it earlier, about how there's this application that must be made to a grand jury, and then the grand jury then has the authority to say, yeah, we want to take up this investigation or not. And so what I fear is if you open this process up to anyone that wants to have a complaint, what you're going to get is an individual that will hit a grand jury, and if the grand jury disagrees with them, go the next month to another grand jury, and that grand jury disagrees with them. And that individual will be able to suck up a huge amount of time and effort from grand jurors, which again are sacrificing their time to serve in this public service. So I think you can't open it wide up, because that'll be rife with abuse as well. I mean, how many shots should someone have to make a case before a grand jury before they no longer can bring that before a grand jury? And I don't know. That's a policy question that I don't have an answer for. But you could see how somebody could spend 15 years of their life trying to get an investigative grand jury to take up one of their charges of public corruption, and after 15 years finally gets an investigative grand jury to do so. And I'm just wondering, is that a good use of public funds and the public's time when they serve on grand juries? The other issue, and I think was the one that with your bill, for example, that there was a worry that if we allowed it just to hijack, and I don't share this worry by the way, but there was a worry within the department that if we allowed an investigative grand jury to sort of hijack this criminal indictment grand jury, then we'd get behind and we wouldn't be able to indict these crimes that we needed to indict. And so the thought at that time, I think that you probably heard this from my department was, well, let's have a separate impaneled investigative grand jury to sort of take these issues on. That way we can still indict these crimes and we won't get backlogged on our criminal prosecution. But I actually sort of disagree with that interpretation. I think the Constitution is clear that a grand jury is a grand jury, whether it just indicts or whether it chooses to investigate. That is the power and authority of that grand jury to make. And so if an individual grand juror can convince the other 11 people on that grand jury to investigate something, then they should investigate. I 100% agree with that. And I actually want to correct on the record last night, and I apologize for making this correction on, we were talking about why there was only 12 grand jurors that were present in a very public investigative grand jury that occurred down on the Kenai Peninsula. And I misspoke, and I apologize for that. So I want to correct the record right now. Actually, the reason why there was only 12 grand juries is that actual grand jury started under the court's restrictions under COVID. And so there was this 6 foot spacing that you had to require in these grand jury rooms. And because of that, the courts themselves limited the amount of grand jurors you could have to 14. Now, this case took years to come through. And by the time it got to the point of calling witnesses, and once the independent prosecutor took it over, because there was concern that because once there became an allegation that the Department of Law was implicated, our prosecutor stepped back. We inserted an independent prosecutor. Once that occurred, there was only 12 of the 14 left on that jury. And so that's what had happened. And that's why only 12 jurors were there. And then when the one decided that he wasn't going to participate or she wasn't going to participate anymore, that brought it under the level of required by the law of 12. And that's hugely unfortunate because that grand jury spent 8 months investigating those issues. And they did issue a report that the court rejected and said, we're not going to make public.
So that's an interesting situation because it is, to the best of my knowledge, the only case or example of a grand jury being able to conduct an investigation and issue a report in my lifetime, in modern times here that I've been dealing with as an adult, and the court's sitting on that report. So looking forward, what's the remedy for this? I think at the time there's a compelling interest that says either the executive branch or the judicial branch should have compelled that person to come back and do their duty.
Yeah.
There's also a compelling
interest from the executive side on that case. My hands were tied because once I turned it over to independent prosecutor, as soon as I start telling the independent prosecutor what to do, they're no longer independent, right? And so the only thing I did was sign the checks that went out to that individual. And by that whole process cost the state of Alaska over $100,000 when you're all in. So there is a price tag that also is associated. So you do 10 of these types of investigative grand juries, we're looking at over north of $1 million for the state. And I think that's a cost that I don't think it should prevent grand juries, but I think we need to be cautious about how we allow a grand jury to proceed and make sure that it is, and again, I don't know who that individual is. It's not me. I shouldn't be making these decisions, but, and then I also, the other part with the rules that the court, so the first part that I kind of disagree with was making me the gatekeeper. I don't think I should be. But the second part was that when an investigative grand jury comes up with a report and they vote on it, it shouldn't have to go back out to the court for approval, right? I think that part taints the whole system of public confidence. And I totally understand why the court has that rule in place, because they want to, there's certain other constitutional rights that individuals have, like the rights of the people that are going to be mentioned in this report. But I think the public, I think the good to the public from that report being issued outweighs some of these other constitutional sort of calculations that should play into this. And so I think that these reports, if they are voted on, should be released to the public. And I was really disappointed that investigative grand jury's report did not get released to the public.
What do you think the solution is for that specific issue? Is this a situation where the executive branch, that the attorney general, needs to sue the courts in order to force them to deal
Yeah.
with this issue? Or, I mean, there needs to be a resolution of it. It can't just
Yeah.
be, it just can't linger, right?
Yeah. I mean, I think, I honestly think it's going to require if you want my honest opinion, I'm going to give it. I think it's going to require a constitutional amendment to make that happen. I don't think I don't think the courts are going to agree with my position that those reports should go to the public, because the public benefit outweighs some of these constitutional concerns of because the whole purpose of these grand juries is to investigate issues of public safety and public welfare, which often is in the form of bringing forward corruption within government itself.
Well, this
With
this specific case in
yeah,
general, or in specific
yeah,
specificity from somebody who was there, is
yeah,
specifically an investigation into corruption within the court system.
yeah,
So you can, just the perception of impropriety here is what's at stake here, what needs to be corrected. What stops the attorney general from impaneling a grand jury with the charter to
yeah.
go investigate this and resolve this issue?
Yeah. No, again, I think that issue's gotta, I think it's gonna have to come down to a constitutional amendment to make that happen. I don't see the courts sort of reversing course on that rule change. And so maybe if there was enough public outcry about it, they might. But I understand their position. If I was an attorney that they hired, I could argue their position all day long. I just disagree with the position. And there's arguments on both sides of that. But I just think the public good of having those reports outweighs some of those other considerations.
Okay. In the interest of time here, I recognize the clock is ticking up to our our hard stop.
Yeah.
Without further administrative action on the court's behalf or on your behalf, the system that you've established here, or any statute changes from the legislature, where do you see this grand jury process going? And is there a risk of returning to a more restrictive process with whoever replaces you?
Yeah. No, there is that risk. So one of the processes is working on right now is because under the Constitution, we talked about it a little bit, we referred to it, an individual that is called to and paneled to do indictments, if they have a concern of public welfare safety, they can bring that issue up. But there really is no process right now for that. It's sort of, and these prosecutors that are out there indicting cases aren't used to a process. So when they hear somebody say, "Hey, I have an issue we'd like to investigate," they're I'm trying to train on it better. But in the past it would have been like, I don't know what I'm supposed to do here. I'm going to call the supervisor, and the supervisor is going to say, I don't know what you're supposed to do here. And so what I'm going to do is make it just like what I intend to do is make it just like what we have for this other process. I'm going to put the process right out there on the website. And that way, if the prosecutor doesn't follow that process, then there's actions that can be taken, right? And the public also knows what the process is. So when a grand juror goes in, they'll know what that process looks like. And then again, if people disagree with the process, they can challenge the process. But if it's not written, it's hard to challenge. So I figure writing it's the first step. And I think when you got both of those things up and we receive public feedback from those things, I think we can make it better. Again, I'm contemplating things like an independent commission. And you kind of want to rotate members through that commission, because then the commission could be involved in the corruption, right? So there really is no easy solution on this. And so I think, I applaud the groups that have been pushing these efforts, because they have brought the things to light that need to be corrected. And so that was my hope when I published that on the website and came up with a process, is that would further bring things to light, further cause more conversations to occur, maybe get the legislature more interested in taking on those issues. So that was my hope.
Well, I suspect that we'll probably see in the future here that the change to the tradition or the constitutional requirement and tradition of keeping things secret is going to get challenged and will end up in the courts. I think that's probably one outcome that is likely to happen. I would also like to maybe just end us and say here, it's an unenviable position from either the court's perspective or the Department of Law or executive branch perspective here, because there is no bureaucratic process for the grand jury. It isn't found within the constitutional authority of the executive branch or the judicial branch. Neither of the heads of those organizations have full control over the grand jury. It's not their baby. It is the baby of the people. And as long as the Alaskans, the people, do not understand their power, they do not understand the mechanics of a grand jury, they don't understand the legal process, they don't train themselves or learn or demand that our schools teach us the civics from a very early age, you're going to get a population that doesn't know what they're doing when they get assigned to a grand jury. And the grand jury is supposed to be the expression of the people, the people's power, right? In the second stanza here on the First Amendment or first section that says all political power is inherent in the people. Well, that's expressed through a grand jury. If you don't know how to do that as a people, just speaking as a large group, if you're waiting on the courts to tell you what to do or waiting on the Attorney General to tell you what to do, then you're losing control of your government because you don't know what you're supposed to do. And ultimately, there is no amount of control or process or whatever that the two branches can put into place, or the legislature for that matter, that's going to make up for a populace that doesn't know what they're supposed to do.
Yeah, education's key on that. And again, the reason why I put it up there was so that every Alaskan can see what that process looks like and be able to apply for an investigative grand jury. And they don't have to wonder, do I write a letter to the governor to get this started? Do I write a letter to the mayor? Do I have to involve the legislature? No, the process is there, right or wrong. And whether I made the right discretionary calls in that's subject for debate. And I'm happy to have that debate. And we're happy to change this to be even more transparent, more accessible to the people. So thank you, Ben, so much for having me on today. I really appreciate the opportunity to kind of walk through this process.
Yeah, thanks for coming on. I appreciate it. Folks, if you've enjoyed what you've heard and seen today, please hop over to mustreadalaska.com, click on the donate link, help us keep the lights on. Until next time, stay frosty, Alaska.